In the second consideration, the specific request had to do with a California case that was pending appeal concerning abortions and access to abortions through appropriations through the Health and Human Services. This was my concern was that in consideration of the fact that there had been a tele-abortion provision that had also been registered concurrent to other provisions regarding telemedication as part of the CARES Act, that somebody was actually using that case, including the attorneys generals of the states involved that were named as litigants in that case or that were named as part of that case. They were using it as a way to place options at their disposal and a form of strategy that could disabuse access to teleabortion services as a form of weaponization effort and or a form of political reprisal for people within their own states that they had targeted and or make it available for use as part of other illicit activities and unconstitutional activities that were going on in the course of this quarantine. And that I believe that it was a serious national security concern and that it was at the level that it required a specific consideration. Now, what recourse do I have? Well, I have whoever is involved with readiness for national security. If somebody puts out an SOS or if somebody puts out an emergency broadcast like that, who do you consider to be your authority in that regard? Do you divert it from an appropriate forum or the direct actual authority to which it should be attributed and it should be directed in order to put it into some clandestine, ultra constitutional pseudo process in order to effectuate your own unconstitutional and illicit acts? I think that's exactly what happened. I don't think it actually got to the people it was supposed to. I think that again, it was a situation where traders from within Texas who feel like they're emboldened to some extra constitutional process interfered and used it for their political opportunistic gains and assassinated a Supreme Court justice. Does the state of Texas feel it is entitled through its own market competition and participation regarding the Affordable Care Act and its state competitive marketplace model to appropriate and or copyright or patent technologies concerning teleabortion to make it available as some form of weapon that can then be created as a product that businesses that identify with or are located in Texas and or contract or subcontract with or through the state of Texas can sell to other people, and hence a challenge to the copyrightable nature of litigation that could provide the foundation for weaponization would be considered something you needed to eliminate as an obstacle, i.e., if I had been able to find that when I needed assistance in mounting my own charges about abuses of my case and my efforts at due process, would it have invalidated any claims that alleged state actors in Texas, including judges, members of the legislature, or former members of the Texas government that have put themselves into the federal government were able to avail themselves of by stealing my legal filings and turning them into weapons that they sold to others and used and or traded with others in order to effectuate extrajudicial political assassination and targeted reprisal against political opposition? There's no dot 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 on that. It's a very direct question.